This is a license to discriminate at the highest court. I think that this is a pattern that we've been seeing with the Supreme Court, where they're taking away rights instead of broadening rights for marginalized communities. We saw it yesterday. We saw it last year with Roe v. Wade for women, and now we're seeing it against the LGBTQ community. So we're seeing a pattern. We're part of it. Where does this stop? So what business can now deny myself and my wife access when we walk in? And I think they've left that really broad. I haven't read the decision yet, but from the top line analysis of it, I think that this is an open license to discriminate against LGBTQ people in America, which this court has signaled they want to roll back marriage, they want to attack the LGBTQ community, and this is their first step in doing so.
Yes, that's right. That was GLAAD President Sarah Kate Ellis speaking on the Supreme Court's decision today that expanded the discrimination that's possible against the queer community as well as other communities, because again, the decision was pretty broad. Here's the background on the case per the Huffington Post. In 303 Creative versus LNS, amateur web designer Lorie Smith asked the court to grant her the right under the First Amendment to refuse service to gay and lesbian couples due to her Christian religious beliefs, because we know Jesus loved to ostracize and mistreat people. But Smith's request was wholly speculative. She had not been hired to make a website for a same-sex couple and therefore had never refused such work. In fact, she never made a single wedding website. Now, Ms. Smith basically sued on hypothetical grounds, which largely, I would say, is not legal. Although there is First Amendment, you could say that a law out there is chilling your First Amendment rights. I have been a part of defending against those cases on behalf of the government when I worked at the US Attorney's Office. So I'm sure that is what Ms. Smith argued, that her First Amendment right was somewhat chilled. Anyways, Lorie Smith has claimed that Colorado's Anti-Discrimination Act, which prohibits denial of goods, services, and facilities because of disability, race, creed, color, sex, sexual orientation, gender identity, gender expression, marital status, national origin, or ancestry, violated her First Amendment right by requiring her to take commissions with what she said was a message she did not agree with, specifically websites celebrating the weddings of same-sex couples. Now, this underlying claim, because remember, she attacked that Colorado statute, which includes a lot of categories. And so the ruling itself isn't necessarily just limited to LGBTQ plus couples. It could hit you on all those different grounds in terms of denying access to opportunity to patronize businesses and to have the same experience of someone else, as long as you fit within one of those marginalized categories. And that's gonna be one of those things that a lot of people start to test at this point, knowing that the Supreme Court precedent out there is now quite broad. And despite this underlying claim really being totally made up as it was, well, the court sided with Smith's religious liberty argument. That was a 6-3 vote, all the conservatives lining up. And Justice Sonia Sotomayor, who was in the 3, well, she joined the other 2 liberal justices, Elena Kagan, Ketanji Brown Jackson, dissenting. And it was really a blistering dissent and completely accurate. And this is what Sonia Sotomayor said. Today is a sad day in American constitutional law and in the lives of LGBT people. The Supreme Court of the United States declares that a particular kind of business, though open to the public, has a constitutional right to refuse to serve members of a protected class. The court does so for the first time in its history by issuing this new license to discriminate in a case brought by a company that seeks to deny same-sex couples a full and equal enjoyment of its services. The immediate symbolic effect of the decision is to mark gays and lesbians for second-class status. In this way, the decision itself inflicts a kind of stigmatic harm on top of any harm caused by denials of service. The opinion of the court is, quite literally, a notice that reads, some services may be denied to same-sex couples. Absolutely. The fact is that this case came up on a hypothetical situation, as this woman had never even created this website. And the court took the bait when it should have challenged standing, because even if you want to argue that a particular statute chills your First Amendment right, you got to put up a lot of evidence that you would have put out that material, that you would have built a website. And the woman didn't do that here. And that's generally the standard of what is required in order for you to even approach a situation and say that your rights are chilled. The fact is that we have a problem, and we're gonna see a lot of litigation coming down the pike trying to get to the US Supreme Court that really seems to undermine whether it's not just same-sex marriage, That was declared lawful in Obergefell, but also interracial marriage, being able to access opportunities. If you are a photographer and you don't want to take a picture of maybe a mixed race child, and so you decide to say no because it's against your beliefs, or maybe someone has a physical disability and you don't want to provide services to them because you don't think that they should have the same accesses. That is what this decision does, is it opens the floodgates for state-sanctioned discrimination, of course, using religion as its underpinning. This is dangerous. Mondale.
I mean, it's dangerous and it's American, right? Like, this is as American as apple pie. And to have Clarence Thomas blackface up there agreeing with all of this is absolutely disgusting, as he sits in an interracial marriage, which was just argued, 40, 50 years ago in this court in Lovett v. West Virginia. I think the scary part of all of this is we don't know how far it's gonna go. We don't know when it's gonna stop. What's gonna happen when, like you said, a racist person say, I don't want to marry two black people, it goes against my belief, or a black and white person. This is absolutely ridiculous. I don't know where they want America to go. But if they have problems with the state of Iran, then they need to have problems with the state of America, because right now we're starting to look just like that government. Our government is just like that. We're banning people for being people. We're making it illegal to be anything other than what the majority wants you to be. And I just, as a black geeky boy from the South, to see Clarence Thomas on the Supreme Court acting and showing up in this manner is absolutely disgusting. And I would say, bravo to how Biden is showing up in response to the Supreme Court, but this is why the Democrats fell short when they didn't expand the Supreme Court when they had all three houses. And this is the ramification for not doing that.
No, absolutely, you are 100% right. Now, I can't speak to Iran, as I just can't, but I can definitely tell you that the US needs to definitely stop looking at the logs in other people's eyes when it's got like some kind of log in its eyes. I don't do that kind of whole thing, but I know it's a problem because we're always saying, oh, well, this country is the problem, oh, this country is antiquated, when really, no, not the case. We need to focus on our own issues.